Good morning. Thank you for being here. My name is Jim Atkins, and I'm part of the Stewardship Committee. And we're very, very happy to present our first seminar of the year on estate planning. And we're really excited about our speakers today. We have some excellent speakers. You'll find a couple things on your table. One of them is an estate planning workbook that was put out by the Presbytery. This is an excellent way for you to put everything you own and have in one place, and it'll prompt you to ask yourself some pretty important questions. And the second thing is a questionnaire that just during this seminar, just complete it and just leave it on the table. It just gives us some idea what's on your mind, what you want to hear about next time, or what did you like, what did you not like about this one. So hopefully we can do 2 or 3 of these a year, and we'd like to make each one better than the last one. So we can't do that without your input. We have 2 great speakers today. First, you know Will Akers is a long-time Presbyterian church member here. Will is going to be leading the presentation, but he also has a young man with him named Kevin Corey, who also is an estate planning attorney here in Ormond Beach. And Will has personally selected Kevin to assist him, so that's a big endorsement as far as I'm concerned. And I have their business cards. There are plenty of business cards here if you have questions that you want to ask them individually, or if you want some contact information about them. So thank you for coming, and I'm going to turn it over to Mr. Will Akers.
Well, I'd like to thank Jim for putting this together. He's done a lot of work, and I'd also like to add to the fact that the Presbyterian Foundation also has materials that you can go online and find in addition to the questionnaire that you have. And there are also other materials available online. I was looking at those recently and found that the Florida Bar also has consumer pamphlets on estate planning, wills, and trusts. So that, and it's very easy to go online to get those. You just, Florida Bar consumer pamphlet, and you can find those materials online. In fact, when I was looking at the bar materials, I will read you some of the questions that they have that I think we're going to be talking about today. For example, what is probate? What is a will? What is the probate process? What are the estate's obligations to pay creditors? And then there's questions about revocable trust in this particular publication. What is a revocable trust? How does that avoid probate? How do I know that my assets are properly titled? So these are the kind of questions I think that y'all are here today maybe to know answers to. And Kevin and I are going to try to do that. So I'm going to put these materials over on the table in a minute. I also have an estate planning questionnaire similar to the one the foundation has. You can buy these anywhere. They're very helpful. They start you thinking about the process of what you do with estate planning. And this is not an easy process. And there's a lot of work involved. In fact, a lot of people just don't do it because it's too hard. In fact, I have read that 40% of attorneys don't have an estate plan. They don't have wills. They're not prepared. I'm representing an estate now of an attorney, well-known lawyer here in town, didn't have a will. He had a pretty substantial estate. So what happens when you don't have a will is the state of Florida makes one for you, and that might not be the kind of will you want. So we'll talk about that too. So I'm going to put these things down over here. And we can get copies of these, more copies for you if you like. So with that introduction, I want to introduce Kevin. I've known Kevin since he was a young man. In fact, he was on my Little League team. And we're happy to have him today because his boys are on Little League and he's just got a little window of time before a game coming up with one of his boys. And Kevin, he was probably the worst hitter on my Little League team. But he was the best kid on the team. And I always loved him whenever he did get a hit. So I'm glad that he came. He and his father practiced law here in town. Some of you may know his dad, Kit Corey. They're in the Granada Oaks Professional Center, I guess you call that, over on West Granada. And he does the same sort of work that I do, wills, trust, estate planning, and probate. So we both do the same kind of things. And I think one day he might be wrapping up what I'm doing. Hopefully not too soon, but he's available for that. So let's just start out about answering some of these what-if questions. So, what is estate planning? It's an orderly process that allows you to give your assets, transfer things to your friends, your family, to your charity of choice. And it does more than just that. It can protect you from creditors. It can maybe reduce taxes that you might owe. It also can manage your health care in case you're not available to give answers to your health care providers. Most of all, it's a way to express your wishes on what you want to do with what you own, the most important thing you have, for the beneficiaries who are important to you. So, what is a will? We'll start off with that, with all these what questions. A will is a document that transfers your assets on your death, but there are really strict rules on how that document is prepared. And Kevin and I were talking about how many mistakes can be made if it's not done right. And Florida law has very strict rules on how wills are done, how they're executed, how they're witnessed. And if you don't do them correctly, then the will is invalid. So you have no will. And as I said earlier, if you don't have a will, whether by mistake or just don't ever get around to it, the state of Florida is going to make one for you. And it's probably not going to be what you want, because it might, your assets may go to a relative that you actually hate. But that's what the state of Florida thinks you wanted. So if you can think of anything, think that a will at least is going to do what I want. So that would be the big takeaway. There are some things that you can't put in a will, and we'll talk about those in a minute, but mainly if you're married, your spouse has certain rights in your estate that you can't draw a will up to negate that. So we can talk about that a little bit, but those are things that, and also your home. Your homestead there are restrictions if you own a homestead in Florida on what you can do with your home. So what is probate? I'm going to let Kevin tell us what probate is.
Okay, well, we always hear that nasty term probate, every connotation you hear. In Florida we have multiple styles of probate. It's not just one big horrible series of events. Probate technically is the formal transition of your assets from your individually through the judicial process, overseeing that distribution and executing what your estate plan is, and through your will. So as you devise the assets in your will, that's where it is. So in probate and through the will, you would nominate who would be responsible and who would be in charge of managing your assets. And they would once you pass, kind of garner and marshal the assets, kind of gather them all, put it all together, and then work with your attorney through that process of transitioning them to the rightful beneficiaries that you've designated. They would address creditors that may come up, and then work on just the overall transition of the assets.
There's another judicial process that state planning can address, is called guardianship. And that's like probate on steroids. It's like, you do not want to go there if you can avoid that. And that happens when you become so incapacitated that you can't manage your own health or your assets. And the court has to appoint someone your guardian. And that process goes on for the rest of your life. And you have 2 lawyers and you have doctors, it's just a train wreck. So you can't always avoid that, but you can do a lot of things that can possibly avoid it. And mainly, that comes with creating a revocable trust or maybe a durable power of attorney. So those are 2 estate planning documents, both of which can maybe avoid guardianship, probably, and maybe even avoid probate. So I think maybe what we should talk about now is what are probate assets? What happens when you have a probate? Certain things do not come under your will, they do not become part of the probate process itself. For example, if Kevin and I own something jointly with a right of survivorship, on my death, Kevin doesn't have to probate my will, that asset goes directly to him. If I named him as a POD beneficiary, you may have heard of that term, a pay on death beneficiary. If I have a bank account or a stock certificate registered in my name, and it says POD Kevin Corey, Kevin doesn't need my will, doesn't need a probate. It goes directly to him on my death. So there are some ways that you can avoid that. The life insurance policies that we know of, the IRAs that you may have, they all name beneficiaries. We hope they do. And in that case, those assets also go to the named beneficiaries without probate. So there's a lot of things that can be done if you're careful to avoid the cost of probate. So there are some essential estate planning documents. Kevin, maybe you can tell us a couple of them.
So, I mean, as we get into the estate planning process, again, typically there's 3 to 4 main documents that we should always look at. Obviously, having a will or a trust, set up in regards to protecting your assets and overseeing how they would be devised, which we've kind of hit on the premise of that. A durable power of attorney, which that's where we're granting the powers to act to another individual on your behalf. So that's where you're granting them the ability to sign your name or take care of your affairs in certain situations that you identify and authorize. Then we get into living wills and healthcare surrogates, which that's where we're talking about making medical decisions on your behalf. Who are you going to authorize to speak to the doctors and have the HIPAA rights to make those decisions on you if you are unable to? The doctors always refer to you first to make those decisions. This is that alternative individual who's going to do that for you if you aren't. And it also expresses what your end-of-life care wishes are or your medical care wishes are, so that they understand what it is and not them making that decision solely based upon their personal opinion.
The other, I think at this point in time, an essential estate planning document might be the revocable living trust that I mentioned earlier. And there's a lot of confusion about those documents. Basically, you create it, you're in charge, you can change it at any time. But the critical element in it is, if you don't fund your revocable trust, you have wasted a lot of time and money. So the trust that you create has to own assets. You take them out of your name and you place them in the name of the trustee of your trust. That's critical to remember. I have clients that I've created trusts for, and they are very happy with them, but they don't ever get around to moving their assets into the trustee. And so on their death, they have to have a probate of their will to put those assets in the trust. And this happens a lot. So if you can remember one thing, if you are going to create a revocable trust, you really, really want to fund it with the assets that you want to avoid going through probate. As I mentioned earlier, the revocable trust is a flexible item. You can say what happens during your life. You can say who gets the assets. You can say on your death where those assets go. You can maintain assets in further trust for minors or other people. It's a very flexible tool, and I'm thinking it's one of the better ways of estate planning, actually. Husbands and wives can create a joint trust so they can pool all of their assets into one document. So I'm recommending serious consideration of doing a revocable trust as part of an estate plan. If you have, Jamie, you got a question?
I do, I'm sorry. Because here you're saying put everything in the trust, but according to my little paper, what does that mean? But forget to transfer your assets to the trustee of your trust.
That's what I'm
Who's the
there.
trustee?
The trustee, when I say that, I'm saying it goes into your trust via, in the name of the trustee itself.
And the trustee is the name of the trust itself.
The trustee is the person who administers the trust.
Oh, got it.
The person who creates the trust is called the grantor usually. So the grantor creates the trust
Right.
and names a person to manage it. And that person can also be the grantor. In fact, usually it is.
Yeah, so typically, again, if we're creating a trust for you, you will be responsible for your trust. So you would be the trustee of the Kevin Corey
Yep.
Revocable Trust.
Okay.
And then within the trust documents, you name a successor who takes over after something happens to
Okay,
you.
then that's what we do.
So you kind of go through that process of you're in control while you're alive, do whatever you want, and until you don't want to do it or are unable to do it, and then that successor trustee would take over and manage the affairs of the trust.
Thank you. And so that is kind of like the person who's your executor could also be the trustee of your trust.
Yes, ma'am.
Got it. That was a good question. Thank you so
Yeah,
much.
it is a good
Good
question.
clarification.
Yes, sir.
So you're saying that you don't have to actually put your list of assets in your trust as long as you have a trustee name?
No.
No.
That-
you
and,
have to put everything.
and I'm glad you're asking that because you really, like the assets that are in your name, your individual name, need to come out of, transfer from your name to your trustee. So if you had a bank account, it would say Joe Blow, trustee of John Adams Trust. That's the way it would be titled. So in the titling of assets is so critical. People don't realize how they own their assets. A lot of people don't.
It's a two-step process. One, the first is obviously creating the document, and in the document it'll say, clearly, bold, defined, what the title of the trust is. And then the onus becomes, okay, now we have to go to the bank. Now we have to go and through the process, update our real estate, holdings to reflect that. Or, if you're in your life insurance beneficiaries or any of those things, walking through all of our identified assets to make sure we properly title them to make this a seamless transition to the trust versus having to get caught up in the probate, then to the trust. So you're kind of doing things redundant and going through it twice.
I have a question.
Yes.
I have a question. If any asset that you own that you have a named beneficiary does not need to go into the trust?
You can name the trust as the beneficiary.
You can name the trust,
Yes.
but if you have a beneficiary name, like on a life insurance.
Correct, you could leave it as that individual and have it outside of the trust. Yes.
Correct, okay.
Yeah, and that's a good point that I was gonna move on to. There are alternative ways of avoiding probate. I mentioned that a little bit earlier. And one of them is what Jim was talking about, is you can name a beneficiary on a life insurance policy or an IRA or an annuity. That person gets that asset without having to probate your will. It goes directly to them. And the other thing that we were talking about is the TOD or POD accounts. If you have a simple estate and maybe you have one child or two children, you could name those children as POD beneficiaries for your bank account, and there's no probate then. So for simple estates, you probably don't need necessarily to have a trust if you have just a very few assets like that. Trusts are more adaptable because they can create many different provisions for death of a beneficiary or things like that. But you could avoid having to do a trust or a will if you only had one account and you named beneficiaries, POD beneficiaries to that account. So that's one.
You have a question? Yes, ma'am.
So, doing this, you don't have to do a will?
If you only had a bank account
Okay, oh, just because of the
or a very simple estate, you could avoid having to probate your will by naming TOD, transfer on death beneficiaries. That's what I'm saying. I'm not recommending that you don't have a will by any means,
Okay,
because usually people's estates are not that simple.
okay.
And you always have assets you don't think about, recognize, I mean,
Well, they can go, yeah,
I mean,
POD,
this is
that's
very,
okay.
you know, complete in regards to the thoughts, in regards to identifying our assets. So as you would complete a workbook like this of identifying assets, we could see what could or couldn't be transitioned without the probate. I mean, the will, we would still highly recommend as the catch-all, just in case there's personalties that need to be transitioned, or who's in charge of any unidentified items that come up. Because, again, all of this is a living document. It can change, under all these scenarios, you can amend, change, modify your trust, the will. It's not etched in stone.
So the will would be pretty much priority for like first step, then go into.
Again, I think as we identify your needs.
Okay,
I mean, every scenario is different. I mean, as Mr. Akers said, not everyone needs a trust. It's a great vehicle in certain scenarios. If our assets are, bank accounts, investment accounts, and a vehicle, when we rent something, then maybe it's not necessary. So, again, so every situation is different, so there's not a clear answer you do or you don't just because of one thing.
The other thing about the TOD and POD beneficiaries is that you might have a perfectly wonderful will that gives everything to the people you wanted, but you've created these TOD beneficiary designation accounts also. Those trump your will. Sorry to use that word. If you have a POD or TOD beneficiary, that person takes as opposed to someone named in your will. So that, and people don't understand that either. There are other problems with TOD and POD is what happens if the beneficiary named in that POD account gets sick, gets divorced, dies. You have a problem then, whereas a will or a trust can say exactly what happens if those unforeseen events happen. So that's why I like a will or a trust, because it can usually address a lot of issues, whereas this bank bank account that you have would not even come close to that. Another thing that I would say is, and you've probably seen this too, Kevin, a lot of bank tellers or bank officers encourage people to create POD and TOD accounts. Oh, you can do that, you don't have to do probate. And that sometimes is good advice, but often they're not estate planners, they don't know the scope of your estate. They don't know whether or not that's a good idea really or not. But they often do that, and I've seen that many times where, oh, my bank teller told me I needed to do a TOD account. So beware of that advice without, knowing your whole estate. I would not listen to that advice. There's some other things I wanted to talk about. It's a little more complicated. It's called homestead law. And lawyers in general, themselves are confused about homestead law. But in terms of estate planning, you are limited in being able to devise or transfer your homestead if you have a spouse or a minor child. You just cannot do it. The only thing you can do is devise your entire home to your spouse. You can't limit the spouse's rights in the homestead. So that's something to remember. If you have homestead property, and most of us do, and you have a spouse, you have a problem with that asset. You have to really plan carefully around that. These problems can be waived by agreement, but typically people don't do that. And they think, well, it's my home, I can give it to whoever I want. No, you cannot. So the other thing people, if they have unhappy marriages, they think, well, I'm gonna delete my spouse. I'm not giving my spouse anything. Well, the state of Florida has a better idea than that. And it trumps your idea of deleting your spouse. And it says your spouse gets 30% of your assets. And your spouse gets a life estate in your home. So, and that's what the state of Florida says about the homestead law. Those are the two things that people, especially if you have a questionable marriage or one you just don't want your spouse to take anything, you have to remember homestead law and that elective share, that what we call that 30% amount. So those are another confusion. Yes, ma'am?
You have a will,
Yes?
and the spouse says, and you're both together, and you say, well, we want to give it to our child.
Yes.
It's in the will,
So if you're married
yeah.
and you give everything to a child in your will, and your spouse later thinks, that's not a good idea. You're dead. Your spouse is saying, oh, I don't like that. The spouse can say, well, I want 30%, and I want to be able to live in this home for the rest of my life. Or I want to have the home sold and I want a half interest in the home.
Let's say that he decides that, that he wanted this property to go to the child, not to him. Would he have to just transfer kind of a thing?
The spouse can waive that, the surviving spouse certainly doesn't have to claim that 30%.
Okay, so the will, even when you say together that you both die at the same time.
At the same time, it would go, if you go to the kid.
Right. There wouldn't be any spouse available to ask for the.
Right. So but if there's that spouse there and you both agreed at the same time that in our demise, that property would go to the child.
Right. While they're
But
alive.
the spouse can still change the will, even though you both agree that.
It depends on whether or not it's a written agreement. So, yeah, a spouse can, you've heard of premarital agreements?
Yes.
Well, there are postmarital agreements also.
Oh.
So the spouse can waive all of these in a written agreement.
But this homestead law is,
The homestead law can be waived by agreement also.
okay, that's.
So, but it's a special separate agreement that would have to be done. So, I think you have the top 10 mistakes in estate planning.
Yes.
And I was thinking maybe we could just briefly go through those. The first one, assuming you don't need a will because, you know, your family already knows what you want.
It's not in the workbook, it was something that was given out and on the bulletin. So
Okay.
you probably should read them.
All right, so,
Yeah, because that was in our letter.
so number one on the list here is assume you don't need a will. Again, these are mistakes you don't want to make. Assume you don't need a will because your family knows how you want to distribute your assets after your death. So it's pretty obvious that that may or may not work at all. And you will may have to have a probate anyway, because if you have no will and you have no plan, you will need a probate. And you can have a probate without a will. You know, it's the process of moving assets to the beneficiaries with or without a will. That's what probate is. So then the next one I have is draw up your own will using a form you bought from a store or online, because this will save money. And I haven't, and I'm sure Kevin has too, seen wills that were pretty well done, but they're not executed properly. And they're not valid. So I can't stress that you should be very careful if you do that. My third one here is don't make a record of your assets and how they are titled, because no one needs to know your business. That's your business. And I know a lot of people that think that. I'm kind of like that myself sometimes. But it's critical, and that's what this questionnaire that Jim has given us is really helpful. So another number 4 on my list here is don't think about or consider that your beneficiaries might die before you, get sick, get divorced, get sued. All of these things obviously can happen to all of us. And if you haven't thought about that, then that can cause a real problem with your estate and your estate plan. Number 5 I have here is think your estate planning documents are okay if you've moved to Florida from another state, or if you had some financial or personal changes in your life. All of those are key points to remember. You may need to see a lawyer if you've moved here from another state, or if someone that you have as a beneficiary has died or gotten divorced, or any of these things we're talking about, or you've had other changes. You really need to rethink your estate plan at that point. Next item, number 6, is the failure to name beneficiaries on your accounts, especially your IRA account or your annuity accounts. That causes a problem. That is a guaranteed need to have a probate if you don't do that. And then number 7 I have here is assume you're going to be healthy and competent until the day you die. And actually, we all probably know this, that we become incapacitated before we die, almost always, either for a short or longer period of time. And you need somebody to take care of your assets or your person in some way. So the power of attorney that Kevin talked about, the durable power of attorney, the healthcare surrogate, these are the kind of estate planning forms that address that issue. I've already talked about this, but number 8 is creating a trust to avoid probate or guardianship, but then failing to fund that trust, so that you have to have a will you have to probate a will in order for that trust to be valid. And number 9, and this one, I don't have any good advice for this, but it says, fail to consider ways to avoid disputes among your beneficiaries. I don't, Kevin, you have an answer?
Again, it's, unfortunately, again, when you get to these situations, death brings families together, or unfortunately it does tear them apart when you start getting down to this side of it. So having a well laid out plan helps, is the best possible means of trying to avoid disputes and arguments, as this is what mom, dad, and uncle wanted. So taking that time as opposed to letting them decide for themselves how the assets would be devised or what's fair.
I have one case I can refer to, a very recent one, where the lady that died left her home to her daughter. She had other children. And this caused huge conflict among the children. And they all came to my office to complain about the will that I had drafted. And when they arrived, they had one of their mother's papers in an envelope that was unopened. And they said, "We don't know what this is." And I never had this happen before. I opened the envelope, pulled the letter out. It was beautifully written. It explained exactly why she left the home to her daughter in a very cogent, very powerful way. The tension in the room went way down, and they're not happy, the ones that don't have the home, but they understood better. And I don't know whether that works for everybody. Obviously, we all can't write a beautiful letter to our children and say how or what we are wanting to do, but it certainly had a good impact in this case. So that's my only thought about that. And my number 10 item here is fail to name competent fiduciaries, and that's a fancy word, Latin word for being trustee, executor, power of attorney holder, healthcare surrogate. All of those parties are, quote, fiduciaries. They owe a high duty of trust and loyalty to the person they're working for. So if you've got to name the right person to do this. And sometimes, and Kevin knows this too, that if you name somebody as your executor, for example, if they're not a Florida resident or a blood relative, they can't serve as your executor under Florida law. So that's
Blood relative, really?
right. So if you name a friend in Alabama as your executor, that's not going to work.
They have to be a Florida resident first. If
Yeah.
they're not a blood relative, they have to be a Florida resident.
Yes.
If they're not a Florida resident, they have to be a blood relative.
But they're
Or.
child.
Yeah, so
Okay.
again, start, number one, your neighbor could do it. They're a Florida resident.
Okay, I thought you said and, both things had to be.
No.
No.
Okay, now, thank you, almost had.
Yes, sir.
My position.
I have two questions that kind of tie together. Are there different types of trust? I think you're talking about revocable.
Yes, there.
And is there a type of trust that keeps assets away from Medicare in
Yes.
terms of life care?
Exactly, there are. There are special needs trusts, and there are Medicaid qualifying trusts. There are irrevocable trusts. Both of those are irrevocable trusts. They can't be changed. There are offshore trusts to avoid creditors. There's any number of trusts. The English devised trust. We inherited that law from England. And those people over there really knew how to take care of their property, especially the kings and the barons over there. And they created the concept of the trust to begin with. And it's an artificial entity. Maybe that's a better way it's a creature created by a person to hold assets forever in some cases. Although there's a prohibition on that too. But the trust is a very, very variable document. It's very versatile. Most people like the revocable living trust because it's changeable. You can do whatever you want. And you can change trustees, you can change beneficiaries, you can do whatever. So you do your probate while you're alive when you do a trust like that. That kind of trust, and I'll mention this also, does not protect you from creditor claims. So a creditor can get through the trust to you. The other thing I'm thinking is that trust that don't protect from taxes. In other words, a lot of people say, well, I've got a trust, I don't have to worry about any taxes. That's definitely not true with a revocable trust. So the main function of a revocable living trust is to avoid probate and guardianship. Those are the two things it does. And those are probably the two things that most people need to be worried about, probably.
I was thinking too, in terms of somebody winds up in a lot of expensive long-term care.
Right.
Still have, you've seen people have to exhaust everything they have before they get any benefit from
Right.
Medicare.
Yep, and that is a worry for lots of people. And that's a specialty area of law that's, Medicaid planning that I'm not, an expert in. I don't know whether Kevin does much of that, but there are limits to how many assets you can own and how much income you have in order to qualify for Medicaid help. And it's about, income-wise per month, it's like about, for an individual, I think it's $2,500 and only like $2,000 or $3,000 in assets. You have to get to that poverty level before you qualify.
And
So,
and then also, and again, they do have a look-back period too. So again, as you get into this planning process, there's typically a 3 to 5 year look-back of your assets and your holdings. So as you get into that planning stage, you can't just deed it all to your kids and transfer it to all the kids and say, I qualify. They go back and look, back. So as you get into that stage, it is a planning process to move towards that position to qualify. There's another question somewhere. Somebody else missed it?
Going back to the executive, did you say blood relatives may serve even though they're not Florida residents?
And it can also be a blood relative by marriage.
Yeah.
So if it was your husband's brother.
Not child.
Yes, ma'am, but again, if it was an in-law or something like that, they would be able to qualify for you as well.
So Kevin, do you have any more top 10?
I mean, it's pretty comprehensive, again, of all what you see. I mean, you see it all. I mean, people, again, obviously think that they've talked to their kids, everyone understands, they're not gonna fight. It brings them back to their childhood days when they argue over who gets the bigger piece of pie. So again, planning it out, I mean, I must stress, is the most effective way. And there's not a cut and dry plan for everyone. Everyone is different.
I have a couple questions.
Yes, sir.
My first question would be, okay, this is all good, but how do I get started? What do I do to get started?
Call. I mean, again, what I always tell my clients, as we get started, is really to put together in your mind what you want where you want your assets to go, what you want that plan to look like. I'm married, I have 2 kids, I want to take care of my wife first, and then, she'll take care of my kids, I trust her, and then to the kids. That's kind of, the simple answer of how we get, then it goes into, okay, I understand what your vision is, what are our assets and how do we do it? And we work into the documents. These can be transitioned without probate. These would have to go through, a will or a trust and work on putting that together. And then we bring the hard questions. What if? What if she passes first? Who's responsible for the kid? What if, you start building layers of questions and you build a contingency plan through it all.
That's good. Couldn't have said it better.
Yes, sir.
Couple of questions, one you might have answered already, but my wife and I have a lawyer down here previously, about 2 years back, made out a trust for us. As we were Ohio residents. Since then, we become Florida residents. Do we need any changes?
You may not need to change your Ohio trust, but I would certainly have a lawyer look at it as well as
We
your
do
Ohio.
have the Florida trust now.
Oh, you do have
Yeah, it was
Florida.
made out by Florida attorney here.
Okay.
Okay.
But we were not Florida residents at that time. Now we are Florida residents. Does that make any difference?
I don't think so. It's a Florida document, right?
Right.
And now you're living in Florida, that just, I think you're okay.
Okay, thank you.
Then what happens if, and it happens a lot, okay, we're currently Florida residents, we got everything done, but because we're in Elk Health, our kids take us out of Florida and now we're in some other state. What goes on with our will, cause I mean, that happens all the time.
It does, people coming here or
Like
moving
this.
away.
Yeah, because you're incapacitated, you're healthy, and so now they've taken you to whatever state they live in, your children.
My answer would be you should see an attorney in the state where you're living. Because our documents may or may not work there.
Yeah, the
They usually
requirements of
do.
every
I
state
guess
vary.
that's not a concern, it's often where that relative, we are incapacitated, but I guess if we had like you said, had somebody for our durable power of attorney and whatever that language is, then that wouldn't be an issue, because we've already designated them, because we're physically or mentally not there anymore, and that,
The Florida power of attorney law does allow you to give your agent a power to create trust for you if you're incapacitated, as well as a lot of other things. Our power of attorney law is very broad,
okay,
but I can't answer where,
that's fine.
I mean, there is, in general for the United States, you know, fair faith and credit of accepting a document that's valid in one state and to be valid in another. Okay, now the process to do that, you know, if someone brings me a New York will and they moved here, never did anything, passed away, and their kids bring it to me, the New York will doesn't meet the Florida standards. So the Florida, and I'm just using examples, the Florida court makes me jump through hoops, find the attorney or a witness, and have commissioners appointed to verify and validate that will so that we could do a probate here in Florida. So there's a process to make the Florida documents valid where you are, but it's a process. And if you were in an incapacitated state, you're probably not becoming a resident of that state. You're probably just going there for care. So you can still be a Florida resident, and then the Florida will would work for you, or trust. So it's a vicious cycle of everything, and every scenario is different as you look at things.
Could I give my daughter in Kansas the power of attorney, and I'm here, no problem?
No problem. And to be your agent and a power of attorney, you don't have to qualify like you do for the personal representative. You don't have to be a relative. You don't have to be a Florida resident. That is just for the probate side of the personal representative. So for your power of attorney, for your living will or healthcare surrogate, any of those things, it can be any individual. There is not those requirements.
How
It is, executor is it's similar to, it's the same terminology, personal representative, executor. There is not those same requirements for those individuals to serve in that capacity. It is just the personal representative or executor. Yes, ma'am.
I've got a question about what she just said, kind of. Let's say that I am, what designates you being a resident? I mean, like, if I'm a resident of Florida right now, but like she said, this lady here, I get incapacitated, our son from Tennessee brings me to Tennessee, and I'm in a nursing home for 5 years. Am I still a resident of Florida though? And what qualifies residency?
that's hard to answer.
I mean,
You have a Florida driver's license, you have are you a voter, you have voter registration, you have other links to Florida. That's what the courts look at to determine where.
Yeah, it's a
you-
factor analysis as you go through things.
So no matter how long you've lived, I've lived in Tennessee in a nursing home. I'm still a Florida resident if I've still got all those things.
I think a court would determine that.
Yes,
And so then, would my will from Florida be more important if I'm a Florida resident, even though I'm in Tennessee?
yes.
Or would my Tennessee will?
Do you have two wills?
No, I'm debating on whether to get, I've got a Tennessee will, okay? And our son's in Tennessee, and he's not coming to live in Florida. We're in Florida, do I need a Florida will? Because I feel in my heart that probably someday he would take me there.
Things can change in the
Well, again, you know, at that point,
But this-
while you're here, again, I would certainly recommend you have a Florida document that conforms to the Florida requirements, so we don't end up in that capacity that that will doesn't work and we create more work for your son.
Okay.
If you ever got in a situation where you had to go for care up in Tennessee, again, obviously, where your residency is, and as Mr. Raker says, it's a factor analysis that we look at, you know, that would be the determining factor. I mean,
But where you're physically at.
That doesn't matter.
It doesn't matter.
no, ma'am, it's
So
kind of
I-
those other aspects.
So if I was a resident of Florida, but I've lived in Tennessee in a nursing home for 5 years, it's the Florida will that would be important.
It would be the Florida will, and the probate or administration would occur in Florida.
And just for clarification, you cannot have two wills in two different states that are both active at the same time.
No.
So whatever one was done last.
You've heard of last will and testament? That's, you could have 100 wills, but the last one is the one that's valid.
I had a problem with the power of attorney that we had done for our son. And, for some reason, and I can't remember what the story was, but, when we had to supply this, a copy of this, they said it wasn't, and it was drawn up by an attorney. And because of the wording, where the notary signs, where it used to be, like a license plate, a Florida license number, and, you know, and she would sign it. But that the law has changed, and, the words must be, and appeared before me. And so it negated this old power of attorney, and we would have never known it had this problem come up where, you know, we had another one done. So how far,
I
I
don't,
mean, could all of us be looking at documents that have not been notarized properly, be null and void?
I don't think so. I don't know what you think, Kevin, but I don't think the advice that that bank gave you was correct. They have changed our notary laws, and there is a specific way that the notary has to say who appeared before them and how they appeared before them. That's a very, very recent law. What is it, about 2 years
Yes,
old?
about 2 years, 2.5 years, when we started the one-line process.
And so we are doing our new notaries forms that way. But I don't think the change in the law 2 years ago totally avoids an older document. I don't
Valid
think so.
documents, you know, that were valid at that time are still valid, they don't become invalid. So I'm not certain,
They wouldn't accept it, so how?
You know,
And-
You can have a perfectly valid document with a current acknowledgement form on it. Sometimes the banks just, that it's not on our form, we're not gonna honor it.
you know, there's
There-
certain
there's-
types of powers of attorneys too that go along with, we have a general one that's supposed to be broad and all-encompassing. Sometimes in like a real estate transaction, they'll require specific ones that, you know, specifically state your ability to sell a property. Or again, then we have springing ones that only take effect when someone does become incapacitated. So again, there's all types of powers of attorneys that come up, so, but again, it should be valid if it was, you know, properly executed. Yes, sir.
If you have your trust and all your proper documents in place, how can you and would you be able to make a deathbed change in your beneficiary or charitable deed, or anything like that?
If it's a revocable trust, you can change beneficiaries as long as you're alive.
But on a deathbed, you need an attorney to document
Yeah,
your
you-
signature.
It still has to be executed properly, yes.
Well, I have a question there too. If you have a revocable trust and say you change your mind, you said, I wanna be cremated in the will, it's already there, and now you decide, no, my, brother gave me a plot and next to my mom, and now I wanna go there. So, do you have to change your whole will, or can you have like a one-page addendum or a codicil or something?
If that's all you're changing,
Mhm.
you certainly could do a codicil.
You could, so you, unless you make huge, big changes of everything, you don't have to like go through it everything again. I know that was kind of a broad question, but that was.
I mean, again, obviously, depending upon how long from the original will to the codicil you're making, I mean, if years and years have gone by, it's still valid, yes. Style, language, form, sometimes changes, it may be good to refresh certain things as you go through that. You know, if it's something that's in the computer already and it's just a change from, you know, cremation to, you know, burial and funeral, it's just as easy to have a edit and a new will than to go and create a whole codicil for you, because, you know, it's already here, and then we're not looking for phantom papers floating around. You have an entire complete document.
And how often would you all recommend kind of reviewing this? Because you're right, you know, people get married, they have new kids or grandchildren and stuff like that, and a lot in your life changes from 25 years ago when you made your will. So, I mean, that's a good point, right?
So, I mean, I always tell my clients, like I said earlier, again, this is a living document. You know, any life-changing event, certainly we need to look at and evaluate the will, what it says, and in the trust, and our beneficiaries with the bank accounts, investment accounts, and life insurance. I mean, personally, again, I know I didn't add my second son to be the contingent benefit. I forgot about him, and then I forgot the process. I didn't forget about him, I forgot to go do it. But, sometimes I wish I could forget. But I mean, it's just that process of doing our homework as our planning process. It's often an uncomfortable item to talk about, discuss, and review, you know, planning our own mortality. But again, doing it now and staying current on what our wishes are is important, and it should be a priority for us.
So more of just a point is that if you don't tell people that you have a will, or you don't tell them very specifically where it is, if you put things in your will like I want to be cremated or I want to be buried, but they don't know that document exists, you may not get what you wanted.
It's a very good point.
That's the other thing to that.
Excellent point. And I meant to mention that, actually. You need to know where your will is, obviously. And you'd be surprised how many people misplace their wills. They might have a copy, but you can't probate a copy unless you can prove that the original was not thrown away or destroyed. So how do you prove that? So it's really hard to probate a copy of a will. So you need to know where it is, your lawyer needs to know where it is, your executor needs to know where it is, your executor needs to know how to get to the safety deposit box or the lock box or whatever. I can't stress how important that is.
When my grandmother passed away, and, my grandfather had a will, and, we had a close conversation he was just telling me, you know, what his plans were and why he was doing certain things. And, so, I never told anybody that we had this discussion, it was just a personal thing, and, come to find out, when he passed away, he had remarried like 2 years before he passed away, and, she said that, there was no will. And, cause the funeral was in Pennsylvania and their residence was in Florida. And so while everybody was up there, you know, mourning and gathering with friends, that she made a beeline and drove straight through to Florida. And, we assumed that she destroyed it. And because no one could ever prove that there was
a will.
that there was a will. So, does it make sense that all wills should be held, with an attorney, or?
Well, some lawyers recommend that. I do not. I don't know what you
We
do.
don't.
Because I can die, Kevin can move to California. I don't think that's a good idea. I think your executor needs to know where the will is. You can put them in safety deposit boxes so that the wife couldn't come here and steal it. You can put it in a safe with a combination that only the executor knows. I think that's a better way, is to keep them in a safety deposit box. Yes, ma'am?
I'm just wondering, when you say a copy, can you not have two? I mean, when you got a will, can you not have another one that's been notarized and considered,
There's only one will.
it's only one physical will, so anything else is a copy?
Yes.
Okay.
And you cannot, a copy is not valid in Florida unless you can prove that that original was not been destroyed. In other words, that the person didn't mean to throw it away. It's very hard to prove that. So you have to know where the copy of the will is, always. I mean, the original. Doesn't hurt to know where the copy is either. Because occasionally you can probate a copy.
You can't, I mean,
But it's hard.
Yeah, it's a process. Yes, sir. No? Okay. Did you have a question?
Final question, in your will, you list your assets, for example, IRA. You should provide your documentation with the account numbers. Is it necessary to put passwords in that anybody can get at?
Again,
Or a lawyer be able to get just through the account name?
Again, I don't personally like to put account numbers on any of the documents. It's not necessary. I don't even say I have bank accounts at Truist or Bank of America, because it may change. We may close that account and it just puts everything on a kind of a witch hunt for everyone to go find everything. What you can do, and it's very beneficial, and I've recommended to a lot of my clients, for your passwords, for accounts and things like that, to make a separate writing and put it with the will. So if you have an investment account and you look at it online, you can say, with a separate writing with the original will, TD Ameritrade 1234, online password, username, and this is the password to enter. Again, it's a lot of homework and it's a lot of work, and when you should really start to think about what your online presence is and where all this stuff is, but it makes it easier for everyone on the back end. And otherwise, you'll start with the transition of your assets, and then all of a sudden, mail will come and it'll be, oh, there's another asset at XYZ that we have to go and kind of restart the process again.
Thank you.
Yes?
If you make the lawyer or ask to be the person to execute your will, so you're the attorney named on that will, you would be given the original, right, and it would be in possession.
It could be, but it doesn't normally.
It's not done that way?
That's also a conflict of interest that you just raised. The lawyer, your lawyer should not be the executor he shouldn't draw himself as executor in the will necessarily, you know, that if that's true, then maybe another lawyer should be drawing that will.
Okay, because I just look at conflicts of two families here.
Again, and the reason behind it is the personal representative or executor is entitled to a fee for their service
Okay.
by statute. So when you write your attorney in,
I mean, I've heard it done.
it's done all over, and they do it quite often. And again, and in certain cases on long-term clients or something like that, where they are dysfunctional family and they really want the attorney to do it in an independent third party,
It does sound.
you know, we do act in that role. But again,
It's rare.
it's rare and it's deferred out to the clients as much as possible to pick another individual, just so that there is no
Gotcha. That's
apparent
good.
conflict.
What are the guidelines for Sturkeys?
That's what it means, you mean?
Yeah, what,
What does that mean? So if you make a gift to your child and then you say per stirpes, that means if my child is deceased and has 2 children, that child's share would go 1/2 to each one of those. We'll call them grandchildren in this case.
what if there's a husband involved?
Husband would not be involved in that scenario.
Devises go to
Down the line.
down the line, so it stays within the family of that individual. Spouses, we love them, but they're not in the line.
Yeah.
So again, they don't have a standing within the state for a share.
One final thing I might mention is the Presbyterian Foundation has some very good materials on charitable giving. And you can go online there and you can see the multiple ways that you can make charitable gifts. Obviously, you can make outright devises, outright gifts, or you can make a gift with conditions. You know, the gift is going to be used for this purpose. So that's something that you can put in a will, or you can execute separate documents like trusts. Again, trust, charitable trust. And the Presbyterian Foundation has a lot of materials on that. I don't think we really have enough time to go into that, but something to think about.
Another thing is, even if you feel like you have absolutely no one left in your family and you're the last man standing, if you at least have a will or a document that gives your assets to a charity, then it's not going to the state of Florida as a whole.
That's right. If you have no heirs, the state of Florida will get what you own ultimately. So a will can direct those assets to a charity that you love.
Keep it out of the hands of politicians.
Yeah. Yeah, occasionally, you know, I get letters occasionally, I'm sure you do. This person's died and there's no estate, and then these assets are going to the state of Florida unless you can show why that shouldn't happen. So, you do want to avoid that. Any other?
No, sorry.
Well, I think we're done. I think we're done unless y'all have more questions.
Thank
Well,
you very much.
Thank you. I'm so sorry. In your packet, there is a form. This was amazing, and some questions were my own, and some were kind of fed to me from other people to say, ask this, ask this, ask this. So here's our seminar questionnaire, which is really, really, really important, because as the stewardship committee, we are trying to encourage people to participate in things that help us and learn and show our thanksgiving to God for our wonderful church. So if you would like, please, 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 the important part as well is number 4, please circle any topics that you would like to see covered in future seminars. This is planning to be the first of 3 throughout the year. And whether it's all within this year or it carries into the beginning of next year. But we would like to have your feedback about what you would like to do. So we certainly appreciate y'all coming so early and staying so long and with your brain of knowledge. I also have this because as a nurse, I guess most people know I'm a nurse. You could take one of these little folders too, that as this was one of the things they were talking about, durable power of attorney, your wishes. Before you go to the attorney, you could kind of look this over and say, these are the questions. Who may want to speak on my behalf? If I'm in a car accident and I have to have a trach, you know, do you want to have that? Do you want to have compressions? Do you want to be everything you can to be alive? Or if I'm gorked out, then I'm gold. So those are the kind of things that you need to have. And these are also free. And I didn't mean to say gorked out, but that's a bad term. So, that's any other questions for Jim? Thank you so much, Jim, for making this happen.
Business cards for both
Yes.
Will and Kevin if you need them.
As I always say, he's the substance, I'm the fluff. I can have it, but thank you, Jim, for that. So take a minute to fill this out, please. And thank you, Amanda, for